the attendees, could you let me know that you can hear us? We'll get started because it's 12 o'clock. My name's Aaron Evenchik. I'm a lawyer at Hahn, Loeser and Parks in Cleveland. I practice in construction and real estate law. I've been involved with the HBA now almost for 2 decades. I'm currently the chair of the Developers Council. We appreciate everybody coming with us today to walk through some of the issues that we're impacting with COVID. I'm joined today by Steve Seasley. He's a partner of mine at Hahn Loeser. He's chair of our labor and employment group. I'm going to make sure that I can see the chat because I understand you all can't talk the way we have it set up. So if there are, questions, do me a favor, please make sure you type them and put them into all participants. I suspect that when you put them in last time, you put them into the host, which is why Kim was able to see that. So if you have questions, put them in for all participants. Brenda gave us a list of questions you guys had. We're going to try to answer them through our slides. If you want to jump to the next slide, Kim. If any of you have questions, or we have a blog, constructionlawinsights.com, where we have a fair number of articles about COVID and its impact on there right now. Jump to the next one, please. So there's really 3 things we want to talk about today. The first is the impact of COVID on your customers, right? My in-laws are building a house right now, and it's been slowed. So what do you have in your contract with your customers? How patient are customers going to be, and what legal claims could there be? The second thing we want to talk about is dealing with some of your subcontractors, those who are saying they need to socially distance more, or their work's going to be slowed more, or any of those things, trying to deal with all of that. The third thing we're going to talk about, and I'm going to let my partner Steve take lead on that, is going to be reopening offices and showrooms. I know you all had a lot of questions on that. These are the issues that Brenda told us you wanted us to talk about, and so let's move forward. Let's start with the first item, delay in completion of homes. So many of you who are building may be finding that trades want to go a little bit slower, and we'll talk about some of the reasons why in a second, or that some of your buyers also might want to move a little bit slower if they have concerns, or if, God forbid, they lost their job. So the question comes, what applies? And I started my career with a home builder who's a member of the HBA. And in our construction contract, the delivery date said it was an approximate date. And it said it was based on our ability to get it complete on this approximate date. But it gave us all sorts of ability to extend based on market conditions. It gave us the ability to extend if we couldn't get the labor. It gave us the ability to extend on lots of different things. It did not have a time is of the essence provision, and it did not have a provision awarding liquidated damages in the event of delay. So the first thing to do is to look at your contract provision. In fact, for all the things we're going to talk about today, these are all very fact-intensive questions. There's no simple answer. Do you have to wear a mask? Do you not have to wear a mask? We're going to get into that. These things are not so simple. It all depends on the other facts that go with it. So question is, can the customer terminate it if late? Again, boils down to how your contract is written. Most HBA members have contracts that make clear that the builder can be late without further remedy or reduction in price. So you want to make sure that you're putting your customers on notice. And in all of these things, communication is critical to let the customer know if there's going to be a delay, why there's going to be a delay, to explain it's COVID. How do you satisfy your customer for late delivery, something that's not your fault? And possible customer claims, right? Customer going to come to you and say, I had to pay additional rent, cost more money to move, whatever those things are. And some of what we've been seeing are builders saying to customers, it's easier for me to give you an upgrade. We'll be willing to upgrade a bath or upgrade a kitchen if you're patient with us on this late delivery. Because ultimately, we all know as home builders that if we provide a great end product, that makes up for a lot of ill will in the process. Because the process is frustrating. This is the biggest purchase most of your customers have ever made in their lives, and it's a challenging process. Another thing to think about is if they do bring claims under the HBA warranty, and again, these aren't going to be warranty claims, but the HBA warranty does require arbitration, and many of you have arbitration provisions in your purchase agreement. Those sorts of provisions can help limit the ability to go to court and keep things out of court that are going to be more easily solved perhaps in a private arbitration, or they're going to be solved or can be solved through mediation. Arbitration is just like court. the parties go and they hire a private judge to make the decision for them. Mediation, or where the parties work together with a neutral third party to try to resolve a dispute. Arbitration is binding like court. Mediation, we're working together. Let's jump to the next slide, please, Kim. So what are owners saying? The Wall Street Journal has been having a ton of articles on this, right? There was an article a week ago that acts of God disputes around the Upswing, and that's what this is. So when we're trying to explain to a customer, even if our contract is silent on some of these things, this is what we call a force majeure event, an act of God event. This coronavirus, no matter who you are, was not anything that any of us could control or stop. Depending on how religious you are, you may see it as an act of God or otherwise, but it is a force majeure event. So you want to look at your contract to see if it references delays caused by acts of God or force majeure event. This is what you need to explain to your customer. And we're going to walk through two legal scenarios right now, and possibility watch I will get to in a second. One of the things that we're seeing on the subcontractor level at times is exploitation of this as an excuse to other non-performance. So if you had a sub, a drywall sub, flooring sub, was unable to perform, COVID gives them a great excuse to buy them extra time. So you just got to sort that out. The lower tiers are also arguing that they can't get their guys there. And some of this, I think, has ebbed over the last 30 days. We're seeing less of this, but initially crews were refusing to show up, arguing they didn't have the proper PPE. They didn't want to be stacked in there with other trades. Some of that's abating right now. People have found a safe way to work. But one of the questions I always ask when a subcontractor says we can't show up is, well, are you smarter than Amy Acton, right? Amy Acton said it's safe if we maintain social distance. It's safe if we wear a mask. And so if you're smarter than Amy Acton, then you're trying to put in place something beyond what the state said. So what are things we're seeing from subcontractors, the type of claims that are slowing this down, and it is going to make it harder for you to deliver on time, social distancing, if drywall crews have to stay farther apart, and a lot of drywall crews at this point are just going to wear the mask and the gloves and say they have no choice but to work within 6 feet. And even that has evolved over the last several weeks as the Ohio Department of Transportation, who's obviously a big employer on projects, and they kind of set the tone for the construction industry, has acknowledged that people need to work within 6 feet, to the point that, and we'll get to this, they've almost said that if you're outside of 6 feet, maybe you can even work without a mask. I don't think that's a great idea, but that's what ODOT has been saying based on pressure from some of the trades. Obviously, hand washing, sanitizing stations, all of those things, if somebody has to go and constantly do that, it slows down their pace. And providing the hand washing stations or the sanitizing, who's going to pay for all that? If you're the builder, you might provide it. Or you'll say to your subs, each of you has to provide for your crews. If it's a force majeure event, generally what you get is time only, and you have to absorb the cost. If you as the home builder decide to suspend on a subcontractor, they can seek costs from you as well for that suspension. So the things we're seeing, crew absence and quarantine, some of that I think is now in the rearview mirror, but again, the slow performance is what we're seeing. Why don't you jump to the next one? Next slide, please, Kim. So the question becomes, who has to pay for all of this? And one of the things that I've said on every one of these lectures, about my 6th lecture on this topic, is right now it's every man for himself. Everyone's willing to take a hit. Everyone's willing to absorb the cost of working a little more slowly. Everyone's willing to absorb the cost of PPE if they know everybody else is taking that same hit and absorbing those costs. Otherwise, people are making claims up and down the contract chain for compensation for the delay for these other costs. So you got to look at who's involved on one of your home construction issues, right? There's obviously a lender out there who's getting nervous about the ability of the customer to repay or about home prices dipping, but the Wall Street Journal yesterday reported that home prices have not dipped from this, which is great. The owner wants to get it done. The general contractor, you all want to get it, and your subs want to get it done, but if it's slowed, who's going to pay for that? And again, right now it's every man for himself. Next slide, please, Kim. So if you can't get it done because you can't get customers there, you have a legal remedy called impossibility of performance, where an unforeseen event arises rendering the performance impossible. And you could argue, I cannot get a drywall crew there. I cannot get these people to work in this small space because they say it's not safe based on Amy Acton's guidance to them. I think that that's less and less today than it was 25 days ago. Next slide. But impossibility of performance can be used to exclude. Next is impracticability of performance. That's a big word, meaning it involves a risk or injury to a person that's disproportionate with the ends attained. So an impracticability means that despite the PPE, despite the hand washing, despite the masks and gloves, we can't still perform this in a safe way, and therefore we are excused from doing it. Again, I don't think that is applying today the way we saw people try to do this 30 days ago, but these are legal remedies that are out there. Next slide, please. Let's jump. So we have impossibility of performance or government actions. Let's jump two more to project delays to contractor. Kim, there you go, perfect. So if you are late due to COVID, you're going to argue that's an excusable delay. When there's an excusable delay, time can't be held against you. You get is time. What you want, if you can, and you can't get this with your customers because they're never going to pay you for the fact it took longer, is an excusable and compensable delay. What the builders have to watch out for are their subcontractors arguing that delays are excusable and compensable, meaning they want more money because their drywall guys were there for longer. If you're the general contractor or the home builder, you're going to argue that was caused by God. It's excusable. We'll give you more time, but it's not compensable. Next slide, please. So if you're dealing with subs and the subs are late, you got to give them notice that they're late. And you're going to hold them responsible for the additional costs you incur if they're late. Now, if they tell you it's a force majeure event or they refuse to perform, saying it's not safe, but you can go out in the marketplace and find someone else to do it, well, then that shows it's not really a force majeure event. They may ask you to compensate them for the cost they incur for these work-pace restrictions. If you're a subcontractor and say, there's an order out that requires me to do that. I didn't put that in my bid. Somebody's got to pay me for it. If you're the general contractor, your position is going to be that we didn't tell you how to do it. The state tells you how to do it. You always have to comply with the law. This isn't on us. And you're going to make that argument. Next slide. One thing you might find are people who do get themselves quarantined and are unable to perform. If there's some of you guys might use some smaller trades where if a man or two go down, that's all the trade can do. In that instance, if they are truly quarantined due to the disease, that will probably be excusable for them, a force majeure event, and it will be hard if you have to go hire somebody else to hold them responsible for that additional cost if they're indeed quarantined. So next slide. So what are some of the damages if you have to slow this thing down or stop? And I don't think any of you have to stop, but if you did, you'd have to secure the site, make sure it's safe. If there's equipment sitting out there or maintaining the site, these would all be costs. And then when you come back, if you got to remote to the site or have equipment brought back out, these are costs that somebody has to pay for. And obviously, if people get raises in the meantime or labor or material rates goes up, these are costs that have to be paid as well. Next thing. So again, what causes these delays? We've talked about this. Social distancing, the loss of productivity. If you have to resequence, my mother-in-law is building a house right now, and rather than have multiple trades work at once, they're one trade in the house a day. You can imagine how that slows things down. The electrician's there one way, the plumber there's the next day, then the drywall contractor follows behind them. So that's a deviation from the planned schedule. And that's a cost that the general contractor probably has to absorb because they can't ask the homeowner to pay that. Hopefully the subcontractors are able to work with that revised schedule without seeking additional costs as well. So those are some things to think about in terms of costs that you might incur. Again, when you're dealing with your homeowners, the key here is to let them know that you're doing your best and to communicate with them over and over so they can plan. If they have to extend rent on their apartment, if they need to rent their home which they're selling to the next buyer or make other arrangements to live in somebody's basement, the more notice you can give them, the easier it is to avoid a surprise, the easier it is to avoid confrontation on that. So I'm going to turn it over to Steve here on reopening offices and showrooms on the next slide. And again, I don't see any questions. I'd say, Kim, if you guys have questions, just let me know. Steve?
Thank you, Aaron. Appreciate the time. Can everybody, Aaron, can you hear me?
Loud and clear.
Very good. Well, hey, thank you for the opportunity. We're going to talk a little bit today about return to work issues, and we're going to focus on safety issues as it relates to return to work. We're also going to deal a little bit with employment law issues so that we look at this globally. But let's start off looking at it from a safety standpoint and examining Restart Ohio. As you know, the state of Ohio has issued a Restart Ohio Responsible program, and it is, there are some required steps and recommended steps, and we're going to those. I think you've all heard this many times before. 6 feet social distancing is required. Continuing to work from home when possible. I think that's an overlooked item. And I will tell you that a lot of our clients today have employees who are working remotely because they can be effective when working remotely. So I think you have to examine that on a case-by-case basis. And a lot of our clients are allowing their employees to work from home if they can be efficient and effective. Obviously, you have masks that are required for employees. That is a requirement with certain exceptions, and we'll walk through those on our next slide. And you've got personal protective equipment, daily symptoms assessments. So I think it's very important that you look at daily symptoms assessments, taking temperatures, keeping a record of those so that you know if somebody has a temperature, if somebody is having COVID-19 symptoms. I think that's very important. Kim, you want to go to the next slide? And we're going to talk, here is the actual slide from Responsible Restart Ohio. And as you can see, they have a mandatory column and a recommended best practices. There was some confusion about the governor's comments recently about whether there have to be masks. So that is spelled out in here. So let's walk through this a bit. It states that we must ensure there is a minimum of 6 feet between people. If not possible, you want to install barriers. Businesses must require all employees to wear facial coverings except for the following reasons. And the primary exception there is if you're in your office and you are working in your office, you're not having interactions with any other employees, any other coworkers, you do mask on. However, once you leave your office and interact with others, go to common areas, maybe it's a meeting room, anything like that, then you're going to have to put the mask back on. I think that's really important today, especially if you're not able to maintain the 6 feet between people. It's important to have the masks on because I think the governments are looking at mortality. So that's why you have social distancing. That's why you have barriers. That's why you have masks. If you go down to the next section, it talks about shift patterns. You want to make sure that you can stagger shifts so that there aren't as many people. That will help you ensure that you meet the 6 foot requirement. You also want employees to perform their daily symptoms. You want them to, if we're giving them the option of taking their temperatures or self-reporting, we need to be diligent as an employer to make sure that happens. Again, requiring employees to stay home if they're symptomatic. I think that's a key, and that's been from the beginning of this pandemic. We've been telling all of our clients to do that. Stay at home if you have a symptom, stay at home if you're not feeling well, and stay at home if you can work remotely effectively and contribute to the overall goal of the business. In addition to staggering or limiting arrivals of employees and guests, any other factor that you can do, such as physical stations and workspaces, you will want to build boundaries, build barriers if you're not able to separate people effectively with just the 6 foot mandate. And we see a lot of restaurants doing that today where they actually build barriers when you walk in to get takeout food. It's important that you do that. Obviously, daily disinfection of all desks and workstation is very important. In addition to that, you want to make sure that if you have any confirmed cases, you need to have a plan and protocol in place. And immediately you want to isolate the individual who has the COVID-19. You want to seek medical care for that individual. And then you obviously want to reach out to the local health department so that you can inform any other employee who may have been infected or had exposure to the COVID-19 patient. And that's a delicate issue because you have to retrace the steps of where that person was working, how close were they to anyone else in the office. You want to maintain privacy rights, obviously. We think that's very obviously important. You don't want to display or identify who the individual was who had the COVID. You just want to suggest ultimately that anyone who had exposure, you want to work with your local health department. And obviously, to clean and get a thorough cleaning of the facility, you'll want to shut down operations for a bit, or perhaps you can do it overnight. We've had clients who had a COVID diagnosis with one of their employees. They did not shut down right away because it was at the end of the shift. They did shut down for that night, and then they had cleaners come in and take care of everything. So those are the factors you want to look at from a mandatory standpoint. The state of Ohio has also recommended best practices. And one of those is that we don't think a lot about is providing a stipend for employees to transportation. Again, that's not a mandate, but you have to be thinking as employers, how do I get my employees to work? How do we keep them safe? And ultimately, how do we keep them employed with us for the duration? Because a lot of employees are going to be fearful. A lot of employees are going to have symptoms that they believe are related to COVID-19 and they're not, and they're going to stay at home. So anything that you can do as an employer to give them confidence and assurances that they're going to be safe in the workplace, you really should explore that. I think it's going to really help your bottom line at the end of the day. Aaron, if we go to the next slide, let's talk a little bit about other guidelines that you have to be aware of. We've talked a lot about the state of Ohio, and I think that's important, but you should be viewing this as a global approach as an employer. You have obligations and certain liabilities that need to be addressed by looking at not only Restart Ohio, but you have to look at the CDC, you have to look at OSHA, and you have to look at the employment laws, which include the National Labor Relations Act, and I'll tell you how that applies. With the National Labor Relations Act, employees are allowed to comment publicly on terms and conditions of their employment. If they're complaining about a term and condition of their employment, if they're suggesting they're not safe in the workplace, and they post something online, a lot of our clients want to discipline them right away. You have to be very careful to protect their National Labor Relations Act rights so that they can comment on terms and conditions of employment. Otherwise, you're going to have a potential unfair practice charge with the National Labor Relations Act. In addition to that, on the employment side of things, when employees come back to work, you're going to have to deal with the Families First Act. You're going to have to deal with the ADA, FMLA issues. A lot of employer scenarios come up where employees might not want to come into work, but they're capable of coming into work. That is a common scenario that happens when we're dealing with this. A lot of our clients will have employees who are fearful and they don't want to come into work because they believe they're going to be infected. I will tell you that you should be flexible with them. You should try to give them confidence that you're taking all of the necessary steps that we've talked about to ensure that they are going to be safe in the workplace. If they ultimately don't want to come back and they're stating that they're too fearful, you as an employer have to make that choice about whether you want them to ride this out. You absolutely have the right to treat that as a job abandonment if you're all of the federal guidelines and all of the state guidelines in providing a safe workplace. But you'll want to have those communications in written form, and you'll want to make sure that they understand that if they don't come back to work, they're most likely not going to get unemployment and they're abandoning their job. So they're not going to have a cause of action against you for not coming in because they're fearful. So that's a delicate balance, and we'd be glad to assist you one-on-one on a case-by-case basis with that if you have questions about that. That's a common scenario, though, is when you have employees who are not symptomatic, who do not have any illness, but they're just fearful. And I think as an employer, you have to have a plan in place to deal with that when you reopen or you have additional employees coming into the workplace. Kim, if we go to the same slide here, I think we have more to put on this slide. So in addition to Restart Ohio, you're going to have the CDC guidelines and you're going to have OSHA, kind of the federal mandates for you as an employer to provide a safe work environment. OSHA provides general guidance for all employers. There's no new mandates or enforcement guidelines through OSHA regarding COVID-19. We just have suggested best practices based on general knowledge of infectious disease. We're going to walk through some OSHA issues now to give you comfort to know what you have to comply with. Kim, if you could go to the next slide, please. How do I protect my company? Kim, and you can keep pushing these all the way through because we'll go through each slide individually. You want to develop an infectious disease preparedness and response plan. Again, that sounds like a lot of information, but it's truly not. You just want to determine potential exposure sources. You want to look at everything from the general public, customers, and coworkers. You want to look at non-occupational risk factors. So I think it's important for you, as more people come back to work, to have a plan in place. And where are the potential exposures? What else can we be doing to make this a safe environment for all of our employees? Kim, you can go to the next one. All right, implementing a basic infection prevention measures. You want to talk about, and I know we've all heard it from day one, and I know it gets frustrating that we have to keep repeating it, but ultimately, hand washing, access to sanitizer. I've had several clients where the local health department go out, and those are easy things to spot. So if you don't have access to sanitizer or hand washing stations, that's going to be a significant issue right away. And if they see that, they're going to have some more flexibility for you. Obviously, telling employees to stay home if they're sick, educating employees and encouraging respiratory etiquette regarding tissues in trash receptacles. Kim, can you go down further, please? Measures to increase social distancing. We go to the next slide then, if we can go through that, Kim, the whole way, please. We want to develop, obviously, policies and procedures to identify and isolate sick individuals. Prompt identification is key in all of this, because the longer that an infected employee is in the workplace, it's going to create more exposure, it's going to create potentially more cases. And obviously, if you have a significant number of cases, whether that's with subcontractors, whether that's with your employees, it's going to potentially shut down operations. So prompt identification, you want to be transparent with workers and encourage self-monitoring. You want to have reporting policies and procedures regarding symptoms and contact with symptomatic individuals. It's important that employees know how serious this is, so when they come back in the workplace, you can identify and have a plan and a policy in place to let them know that they must comply with these initiatives. And if they don't, they could be subject to disciplinary issues. Isolation procedures, identify the area to quarantine, restrict access to certain areas. All of this stuff should go into your plan. And again, we'd be glad to individualize a plan for you and your workforce. Tim, could you please go to the next slide? We talked a little bit about subcontractors. You obviously want to monitor your subcontractors and suppliers and make sure that they adhere to the relevant COVID safety policies and procedures. If they're not doing it, it's likely to infect your workforce, it's likely to infect theirs, and it's also going to affect your bottom line. So I think it's very important that you treat subcontractors and suppliers for purposes of COVID-19 as if they were your employees. You want to make sure that they are doing all of the things that need to be done to make it a safe workplace. Okay? Kim, we can go to the next slide. Workplace controls. You want to talk a little bit about, there's two forms of workplace controls. Controls, which we've been talking about. Anything that we can do as an employer through policies and procedures to help us eliminate risks associated with COVID-19. Those are administrative in nature. Those are human controlled. Engineering controls, these are mechanical measures that do not rely on employee behavior. So if we go to the next slide, we'll talk a little bit about what some examples are of engineering controls. Engineering controls include barricades, increased ventilation, high efficiency air filters, and obviously any type of demarcation of a 6-foot separation. When you go to a grocery store today, it's nice to see when they have 6 feet with tape so that everyone knows where they need to be when they're waiting in line. It's that type of physical barrier or physical guidepost that gives you and your employees the necessary guidance and structure that they need. Examples of administrative controls include encouraging sick workers to stay at home. I think I've said that 3 or 4 times now. I apologize for being so repetitive, but it's very, very important. Minimizing contact among workers, staggering shifts and trades, and obviously educating and training your workforce. You know, one of the things that OSHA is going to look at, one of the things that local departments of health are going to look at, in addition to seeing the PPE, they're going to ask questions about what you have done as an employer to educate and to train your employees about this. Please do not assume that your employees are going to know all of these in Ohio or all of the CDC or OSHA provisions. You're going to have to implement a plan for them. You're going to have to educate them, and you're going to have continuous training, because unfortunately, this is going to change and be a very fluid situation over the next month, 2 months, 6 months, 8 months. Unfortunately, we know so much more now about this. And if you think about our counseling, whenever we dealt with this 6 months ago or 6 weeks ago, much different message today than it was 6 weeks ago. So it's important to be flexible as an employer. It's important to know that these are the current mandates, but that these mandates most likely will change as the epidemic changes. So I think it's very important for you as an employer to stay fluid, stay flexible, and ultimately seek help from legal counsel and human resources as you need it. Couple more slides and we'll be finished here. Kim, if you can go to the next one. Personal protective equipment examples are gloves, goggles, face masks, face shields. Face masks are the big ones. Those are what are required now under the Restart Ohio program. Respiratory protection, probably not necessary at this time unless you're in an environment where you think it's needed. Next slide, Kim. OSHA standards, and I just wanted to close on this because this will give you an understanding. Ultimately, you have PPE standards under OSHA that relate to COVID-19, but the general duty clause, and Kim, you can go to that next, and just a brief comment on the general duty clause. It states, Section 5A1 of OSHA Act states, requires all employers to furnish to each worker an employment and a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm. That's a very high standard. And again, I can't give you legal advice over the webinar today, but I can tell you that the general duty clause, ultimately, for employers to abide by that, I think it's a very doable situation based on what you have in Restart Ohio. If you're following everything in Restart Ohio, what we just went through, all the factors about social distancing, providing a washing station, barricades if needed, staggering work shifts, those really are the keys. And if you're able to do that, please understand that you're complying with this clause. You know, I think this is a very high standard for employees to meet and to say that you weren't providing a safe work environment. If you do the things that we just talked about, which are highlighted in Restart Ohio and under CDC guidelines, you're going to be in good shape here. I think the government's going to be flexible. I think the courts are going to be understanding that this is a new pandemic, that we are doing the best we can as employers. You just want to make sure that you're not relaxing guidelines when they can be relaxed, such as face masks. Those are important things to police and to make sure that these have access to face masks. If they don't have one, we should be providing them, in my opinion. I don't think it's a mandate, but ultimately, if someone doesn't have a mask with them, provide them with a mask. Make that investment so that all employees have access to a mask. You can see where that's going to protect your interest down the road. If an employee says, I couldn't wear a mask because I didn't have one, there was no access, it's going to be like any other PPE requirement. They're going to state that you didn't provide it in a timely fashion, or they didn't have it when they needed it. So make that investment now before your workers come back, so that they cannot make that argument that you violated the general duty clause. So with that being said, I think I've reached the end of my presentation. And Aaron, I think we might have some questions to address.
We did. We got some questions. Steve, you can hear me, correct?
Yes, I can.
Great. So we got some questions from Brenda. The first one says, are you bound by a contract that does not allow you to perform because of COVID-19? If somebody, I'm repeating, so somebody could mute for a second. Maybe Steve or Kim, I see you guys, or Ellen. But we went through, I think, and answered that question. If you can demonstrate to your customer the impossibility of being able to perform, there are legal remedies. We went through some of those slides. I just question if you can't find a replacement trade today. You'd have to demonstrate and show I made phone calls, I kept records of people, I sent emails, look court. I tried everything I could to perform. It's impossible. There was nothing else I could do. If you could do that, it could be excused. Number two, as an employer, what happens if your sub or trade are uncomfortable working in the COVID environment and they refuse to work? Again, it goes back to the same thing. If they refuse to work because they're uncomfortable, as Steve said, those Amy Acton guidelines, this Responsible Ohio, which lays out what you can and can't do or what's required. Anything beyond this, we saw a provision from a general contractor on big construction projects that said people working within 6 feet had to have masks and face shields and 2 sets of gloves. We all looked at it and said, oh my God, it's like they're going into surgery. And again, are you smarter than Amy Acton? If Amy Acton said it's safe to work with the PPE, with a mask, with gloves for limited time in that environment, having all that other stuff isn't necessary. And when you have a sub who refuses to perform, so long as that you can find a replacement who's willing to perform, it makes it harder for them to argue force majeure. Third, next question. It says there's confusion with the rules needs to be followed on the job site and in the office regarding face masks. And I think Steve made very clear that when you're on a job site, face masks are required, especially if you're going to be within 6 feet and try to avoid being within 6 feet. I will say that the Ohio Contractors Association and ODOT have put some guidance out there that hinted you might not be required to wear a mask if you're working outdoors and you're separated by more than 6 feet. We've heard some Amish crews were pushing back on face masks as well, and I'm not sure why, but we've seen that. Certainly when you're within an office, I know within our office, we go, and I haven't been to my office in almost 60 days. When you're walking around, you have to have a face mask on. When you go into your individual office, and I have an office, you can take your mask off. People working in a cubicle within 6 feet of each other, probably we've moved their chairs to distance, but working out in those sorts of spaces, they should have their masks on. 4, should you have a sign-in sheet? I'm going to let Steve take this one. Should you have a sign-in sheet when employees arrive that can confirm they took their temperature in the morning and are not running a fever? Steve?
Yeah, I think that's always a good measure if you can do it. It again disputes anything if somebody makes an allegation that they weren't tested or that we're not following our internal policies and procedures. One of the things that OSHA will look at is if we have policies in place that mirror Restart Ohio and we don't follow those daily, that's direct evidence of a breach and a potential lawsuit. So the more evidence that you have to support it, the better. Now, if you keep a timesheet or you keep a record of who gets their temperature taken, please know that if you miss a day or if you miss somebody and you don't record them and you did take their temperature, that could be used against you as well. So my only advice on that is if you're going to keep a record, make sure that it's complete, make sure that it's accurate, and make sure that you dedicate the resources that you need to do it every day.
Awesome. We have a few more questions here. Number 5, if an employee pardon me, as an employer, if you think that although an employee can work remote from home, it's better for them to be in the office, how do you enforce that rule? And Steve, I'm going to ask you to comment on that. I do know that Responsible Restart Ohio for offices said in there, employees, let's see, it did say in there that people should continue to work from home as much as possible for general office. But Steve, if somebody wants to work from home, can you require them to come in?
You know, ultimately, that's the employer's decision. And you should have an objective basis as to why that employee works better in the work than at home. You can see this can lead to discrimination claims if you're allowing certain members to work remotely, certain employees to work remotely, but you're requiring protected class employees to come in the office. So it could draw a discrimination claim, but ultimately, if you have some objective criteria that they work better in the office, that they need to be in the office, you can mandate that. I would tell you over the next month, I would be flexible with this, and I would err on the side of caution. And if you think somebody can do the job from home, I would allow them to work from home at least through May. Let's see what happens in June. But ultimately, I think that's your choice, but it should be backed up with some objective evidence as to why they need to be in the workplace.
Awesome. I'm going to jump to the seventh question, and then we'll go to the sixth. 7 was, Steve, what was Ohio's ruling regarding furloughed workers that will not come back to work when everything reopens? So if people are refusing to come back, because we've seen some people say they'll make more money on unemployment. So what happens to people who refuse to come back when you call them back?
Ultimately, if someone is furloughed and they don't come back to work, they need to understand that if they're capable, if they don't have the sickness, if they don't meet any of the other criteria for paid sick time or the paid FMLA, then you can mandate as an employer that they come back, that the furlough has ended. And if they choose not to come back, as long as you put this in writing and have an adequate email trail with them, that's an abandonment of their employment potentially. So give them the opportunity, let them know ultimately that they should come back, that they're needed back. And if they refuse, that can be a job abandonment.
Awesome. And then the final question we have here, it said, how do we best prepare for the fall if another wave occurs? Let me just give my brief on that, and then Steve can jump in. One of the things I've seen happen are, especially in some of the big public owners, have put a provision in the contract that says the price and schedule presumes and shifts the risk of COVID delays to the builder or the subcontractor. And I think that's really obnoxious. I think that we really are all in this together and that we need to react that way. So one of the things we can do to prepare for the fall if another wave occurs, well, I think we've been doing that. We have put in place the ability to work from home. I know that in our firm, Steve and I are both at home right now. My printer from my office is behind me. And as we slowly start to move our way back to the office, I'm leaving that here. Over the last 30 days, I never worked from home like this. We've all learned to work from home. For those of you in the office or on sales, you've learned to do that as well. For those of you with models, you probably haven't been able to operate them much until now for the last 45 days. But we'll adapt. The key measure that I think all of these things are designed to control is how many people get sick and what the hospitals can handle, because people will get sick. There's nothing we can do to prevent that. The good news is I think a lot of people are recovering, but I think we are all in a much better place now, having been through this, that if we hit another wave of this in the fall and things have to shut down again and businesses have to operate remote, that we all kind of have our hands on the tools to do that, presuming that businesses are able to survive the loss of revenue with another one of these hits. Steve, I don't know if you have anything to add to that.
Yeah, my only addition to that would be what you do now, 14 days to 8 days is going to be very important if we do have a surge in the fall. You want to make sure that all of your employees are trained. You want to make sure that all of these guidelines are in effect, that they're strictly being enforced and followed. And if you do that now, if you invest now to make sure that your workplace is safe, if there is a surge and you're an essential business, you're going to continue to operate under those guidelines that you have put into place 3 or 4 months ago. and your employees are going to know how to act and be profitable and productive in those environments. So I would recommend that what you do now is going to have a large effect on whether you continue successfully if there is a surge.
Awesome. Well, I want to thank Brenda Callahan, Executive Director of the HBA, and all of the HBA members for inviting us here today. Steve and I are honored as always to present and to answer any questions. Our phone number and emails are up on your screen, so if you have further questions after this, you're always welcome to reach out to us or ask Brenda and she'll reach out to us. Again, we hope everybody stays healthy, and thank you very much for your time today. Thank you.
Thank you, everyone.
Thank you, Kim and Ellen. Thank you.
Thanks, everyone.